The ultimate problem, though, lies not at justice, but at the very top with the president. And we really have to thoroughly appreciate that fact in order to have any hope of coming up with ways to make progress during this administration. So first, just a little background. The president, of course, is not above the law. In our system, the president clearly has a constitutional obligation to ensure that he and his administration comply with the laws. The constitutional text states that the president must take care that the laws be faithfully executed. So one of DOJ's chief responsibilities is to give the president the legal advice he needs, and that job falls to the Office of Legal Counsel, and that's where I worked for 5 years. And OLC's legal determinations are binding on the executive branch unless they are overruled by the Attorney General or the President, which is a very rare occurrence. So now, as I said, the root cause of the current crisis at DOJ is President Bush's utter failure to honor this most basic constitutional obligation to faithfully execute the laws. President Bush, and you have to also mention his Vice President Cheney on this, they've set a tone of disregard for the rule of law, and especially disregard for statutes enacted by Congress and Congress's role generally in our system. As many of you, I hope, know, former head of the Office of Legal Counsel, Jack Goldsmith, recently published a must-read book called The Terror Presidency. So Goldsmith's book, and also another excellent book, Charlie Savage's book, Takeover, and many other reports as well, confirm that President Bush, Vice President Cheney, and their top advisors, they have been deeply hostile to any checks on their counterterrorism policies. And so that's not only external checks from the courts and from Congress or from public advocacy groups or the press, even legal checks from within the executive branch, from the president's own lawyers. So rather than respecting DOJ's traditional independence, they've made clear that what they want are forward-leaning, and that's in quotes, forward-leaning legal opinions that would justify preferred policies. And that's in order to immunize government officials from prosecution. And Goldsmith, in his book, he aptly describes an OLC opinion as akin to a get-out-of-jail-free card for government officials who violate laws. Quickly, just two prominent examples that hopefully everyone is familiar with. First, for years, you'll remember the Bush administration engaged in spying here in the United States without complying with the FISA statute's warrant requirements. And you'll recall this was the context for the White House's unsuccessful hospital visit to then Attorney General Ashcroft when he was in intensive care. The second issue, just want to remind you of, is coercive interrogations. In 2004, we learned that about the infamous 2002 OLC torture memo, an opinion that Jack Goldsmith describes as so deeply flawed and sloppily reasoned that he felt he had to either withdraw it or resign from OLC. So Congress subsequently outlawed not only torture, but also cruel, inhuman, and degrading treatment of detainees anywhere in the world by the U.S. And last week came the truly astounding news that OLC once again issued secret interrogation memos, and this time they found that all of the most extreme CIA interrogation techniques are lawful. And incredibly, OLC found, reportedly, we don't have the opinion, but New York Times reports that they found even simulated drowning through waterboarding is not cruel, inhuman, or degrading. Now, that's their legal interpretation. All right, so that's the problem. Very depressing. What should be done, what can be done in the next 18 months? Clearly, what we need to do is restore OLC's tradition of independence and integrity. And a few years ago, I worked with 18 other former OLC lawyers to try to do just that. We were appalled at the first torture memo, and so we sought to develop a set of principles that could help prevent that sort of terribly corrupted legal advice giving in the future. It's clear from the news last week that of the new torture memos that we haven't yet been successful in convincing this administration. Time's too short to describe all of the principles, but they are available outside on the table, and I urge you to pick up a copy. I'm just going to mention quickly a few highlights. All of these principles are drawn, as the introduction says, from long-standing practices of the Attorney General and the Office of Legal Counsel across time and administration. So very much a bipartisan set of principles. First and foremost, and I quote, "When providing legal advice to guide contemplated executive branch action, OLC should provide an accurate and honest appraisal of applicable law, even if that advice will constrain the pursuit of desired administration policies." So in short, OLC and the Attorney General have to be prepared to tell the President no, and that's what the law requires. And other principles elaborate on this. For example, OLC is not supposed to simply determine how a court would rule, whether a court is likely to say a proposed governmental action is unlawful. To the contrary, on issues such as national security, where the courts are unlikely to closely scrutinize the action, the guidelines say the President and OLC have a special obligation to ensure compliance with the law, and we certainly practiced that when I was there. The guidelines also recognize OLC's legal advice should not end with saying no. Your role is also to help the President and others craft lawful alternatives to accomplish the President's objectives. Other principles speak of the President's constitutional responsibility to respect Congress and the courts, and also of the need for internal procedures. For example, to guarantee that there's input from other knowledgeable and affected agencies in the government. Last, but very far from least, avoid secret law. And here I quote, "OLC should publicly disclose its written legal opinions in a timely manner, absent strong reasons for delay or disclosure." Now, of course, there are situations where secrecy is needed, such as to protect the identity of a covert agent. But public disclosure it's especially critical whenever the executive branch does not fully comply with a federal statute. And recent reports say, for example, that's the case with the recently enacted McCain-sponsored ban on cruel, inhuman, and degrading treatment. So at a minimum, the President must tell Congress and the public when he does not comply with a statute, exactly as written.